Welcome to the Tech Agriculture Law YouTube channel. I'm your host, Tiffany Lashmit. We are coming into Thanksgiving week. I want to wish all of you a happy holiday and let you know there is no shortage of agricultural law news over the last couple of weeks. So let's get caught up on our roundup for November. So first of all, we'll start off with the fact that the government has reopened. The federal government is reopened, and in the bill that did reopen the government, it also extended a number of farm bill programs for the next year. So from an agricultural law perspective, important to know that and be aware that those programs have been extended. Number two, there has been a new WOTUS rule proposed by the EPA and the U.S. Army Corps of Engineers. If that feels like deja vu to you, that's because we've done this a number of times in the last decade or so with a variety of different rules being proposed by different administrations. The rule is just being published in the Federal Register. There'll be 45 days for public comment on that proposed rule. We'll link to that website to make those comments in the show notes below. Quick rundown, a couple of highlights from the rule. There are new definitions of a number of kind of key terms included in this proposed rule. There are definitions for the term relatively permanent. There are definitions for the term surface, continuous surface connection, and the term tributary. Also, the rule will remove all interstate waters from being deemed jurisdictional just by virtue of being interstate. It will also add back groundwater to the specifically exempted categories of water. So they'll take comment on the rule for 45 days. They'll review those comments, make any edits, and then they'll publish a final rule. There are very few things I'm certain of in the law. I am certain we will see lawsuits filed after that final rule is published. Number three, the Trump administration has announced that it's going to be asking the Department of Justice to investigate the big four meat packers. That's going to be JBS, Cargill, Tyson Foods, and National Beef. And they're going to investigate to see if those packers have engaged in any sort of activity that violates antitrust laws. So that's certainly big news in the agricultural sector. Speaking of Tyson, it was announced this week that Tyson Foods will be discontinuing their use of a couple of kind of carbon-related marketing claims. Specifically, there was a lawsuit filed against Tyson. If you follow the Texas Agriculture Law blog, you're familiar with that lawsuit. Tyson's agreed to settle the suit. And as part of that agreement, they have said that they will no longer continue making their claim of net zero carbon emissions by 2050, and they will no longer market climate smart beef. They've agreed not to make those claims any longer, and any new claims that they do make will have to be verified by experts. And that's, again, part of the settlement agreement in that greenwashing lawsuit that was filed against them. Tyson, importantly, said that they are not admitting any wrongdoing, but they are going to settle the case for those terms and certainly others as well. But those are the key ones related to those carbon emission type claims. Next up, let's talk about a lawsuit out of the United States Court of Appeals for the Ninth Circuit involving California's carbon emission reporting rules. You might remember from prior blog posts and podcast episodes, we talked about the fact that the state of California passed a number of carbon emission reporting requirements. This lawsuit challenged two of those. What the court has done is for Senate Bill 261, the court has issued an injunction. And so Senate Bill 261 would have required all corporations with gross revenue of at least $500 million doing business in California to report emissions. That's been enjoined pending litigation. So that means that will not be enforceable as the litigation continues about the legality of that claim. This is kind of critical from a timeline standpoint because that law was set to go into effect in January of 2026. The lawsuit also challenged another reporting requirement, and that was from Senate Bill 253. The court denied an injunction there, so they're not going to pause enforcement of that. That specific provision is requiring emissions be reported for companies with over $1 billion of sales that are doing business in California. The deadlines for that one are Scope 1 and 2 emissions have to be reported by June of 2026, and Scope 3 emissions have to be reported by 2027. So the court didn't issue an injunction on that rule. Again, not as critical from a timing perspective because it wasn't set to go into effect the first part until June and the next part until 2027. So that's the status on the injunction, motion for injunction. The lawsuit's going to continue, right? And the court will decide the merits of those claims. Lastly, I do want to mention there has been a bankruptcy announcement from a grain company in Nebraska. Hanson Mueller has filed for bankruptcy. There's been a lot of news articles, information for folks. If you're somebody who is affected by that or knows somebody who is, I would encourage anybody involved to consult with an attorney immediately to try and figure out the best steps to take, what your rights might be, things like that. Certainly, if you are a creditor, you want to make sure that you file a proof of claim in the bankruptcy proceeding. Get with an attorney licensed in your jurisdiction for help on that issue. So with that, I hope everyone has a great holiday. Thank you so much for tuning in to the Texas Agriculture Law YouTube channel.